Hello everyone and welcome to WFW Employment and Immigration Team's first webinar of 2022. My name is Devan Khagram, I'm co-head of the employment team and I'll be moderating today's session. We've got a variety of presentations today. Sarah Gill will be covering future developments in employment law now that things are starting to move forward again. Emma Branning is going to look at some key decisions on unfair dismissal and firing and rehiring. Elliott's going to provide us an update on immigration and the challenges now in the UK immigration sphere. And finally, Aarti is going to focus on the government's living with COVID plan, specifically looking at the requirement for employees to isolate and sick pay implications now that the rules and guidance is changing. I'm going to hand over to Sarah now to talk about future developments. Thank you, Sarah.
Thank you, Devan. As Devan just said, I plan to give you an overview of some future developments in UK employment law that may be introduced in the coming months. Could I have my first slide, please? So the first thing I want to talk about is pay transparency. 2022 could be the year of pay transparency for UK employers. The deadlines for submitting gender pay gap reports are expected to return to normal this year, having been extended in 2021 because of COVID. And also the rules governing gender pay gap reporting are also set to be reviewed by the government. Changes could therefore be on the cards, but we expect that any changes that are made will be subject to consultation before being introduced, so we may get an idea of what might be coming. As some of you will be well aware, some managers still regard secrecy around pay decisions as an essential element of workplace control and a crucial part of their managerial prerogative. However, lack of pay transparency is a key reason why pay-related grievances and claims arise in businesses. So I'm just going to put up shortly on your screen a poll question, which should appear shortly, and I'd be grateful if you could please answer yes or no. To mitigate risk, is the system of compensation in your business equitable, well managed and well communicated to employees, or could things be better? Be grateful if you could answer yes or no to that. So, oh, this is great. You're all doing the right things, clearly. 68% of you are saying yes, or things could be better, I should say, and 32% of you are saying no, they think that things are good at the moment. So obviously I think there's a lot of businesses out there that could do better. Next slide, please. In addition to gender pay reporting, the reason 2022 might be the year of pay transparency is because we might finally see some progress made towards the introduction of ethnicity pay reporting. Now that's been touted for many years but has yet to be introduced, and many commentators expect that 2022 may be the year that it is finally introduced. The first step will probably be the publication of guidance for employers wanting to report on it, possibly on a voluntary basis. And employers may opt to do it to demonstrate that they're seen as the employer of choice in the workplace. And at a time possibly when some businesses are finding it hard to recruit, that might be quite helpful. But gender pay gap reporting and ethnicity pay gap reporting isn't all. And that's because at the end of 2021, the UK government launched a consultation on the potential introduction of disability pay reporting. And that consultation is open until tomorrow. And the government has indicated that a response will be published by June this year. According to recent TUC analysis, disabled workers currently earn 20% less than their non-disabled colleagues in the UK. In addition, far fewer disabled people are in employment, and it's estimated that their employment rate is about 28.4% lower than those who are not disabled. Currently, you may or may not be aware that there's a voluntary reporting framework in place for disability pay reporting, but a recent CIPD poll indicated that only 21% of employers were actually aware of it, and 54% of them said that they had no plans to adopt it until they had to. The first step in calculating disability pay gap might be for employers to identify who their disabled employees are, and that obviously, for obvious reasons, isn't necessarily straightforward. So you may have to grapple with how do you encourage people to declare their disability, and whether data should be done on an anonymous basis or on an open basis, presumably anonymous, and what's the best way to define disability. We have been told that one is, as and when this is introduced, the government will be giving us some guidance and steer on these issues. We expect that if it is introduced, disability pay reporting will start with the largest employers, as it started with gender pay gap reporting, and apply to smaller employers over time. Next slide, please. The next issue I just want to make you aware of is that 2022 could also see some changes to the Modern Slavery Act and it being strengthened. When the changes are introduced, which could be this year, companies that are in the scope of the current reporting requirements may need to pay even closer attention to their anti-slavery statements. This comes on the back of a public consultation which was launched in July 2019 and an independent review commissioned by the Home Office to assess the effectiveness of the Act. The public consultation sought views from businesses, public bodies, investors and civil society on a range of options to strengthen the Act's transparency requirements, because that was seen as the area in which it was weakest. The government's response accepted several of the recommendations made by the independent review, and the government has indicated it's committed to make key changes to the Act, including mandating certain topics that the statements must be required to cover, requirement statements to be published on a new government-run modern slavery register. Now, this was launched recently, but currently it's voluntary as to whether you publish your statement on that. However, publishing it on it is encouraged by the Home Office. It's expected that we'll have a single reporting deadline for statements, and there's a possibility that we may have the introduction of financial penalties for organisations that fail to meet their requirements under the Act's transparency provisions. Next slide, please. In June 2021, the Modern Slavery Amendment Bill was introduced in the House of Lords, and it proposed various amendments to the Act, which is quite interesting, which included to make it a criminal offence to supply a false modern slavery statement and human trafficking statement, to make it a criminal offence for companies to continue to use supply chains which fail to demonstrate the minimum standards of transparency, and also a requirement to improve standards of transparency in supply chain in relation to modern slavery. This development is the latest in a series of recent efforts by the UK government to increase the obligations on businesses to prevent modern slavery from occurring in their supply chains and organisations. Next slide, please. The next thing I just want to flag to you is that we are also expecting a flurry of new family-friendly rights. In August 2022, EU member states need to have implemented the EU Work-Life Balance Directive. Now, post-Brexit, that doesn't apply to us in full, so we've no need to implement it. However, the UK government has promised to match some of the rights that are contained in it, and the rights that it's promised to match are the new rights for carers. Under the government's proposals, working carers will be able to take up to 5 days carers leave each year to help them carry out their caring responsibilities. The proposal is that the leave will be unpaid, and the government published some detail on how this new right might operate. It will apply to employees who have a spouse, partner, civil partner, child parent, household member, or someone else who reasonably relies on them for care, i.e. a dependent. The person being cared for must have a long-term care need, and this will be defined in the legislation that will be put in place, such as a long-term illness or injury, a disability, or even issues relating to old age. And importantly for you to know, it'll be a day one right. So employees won't have to have a period of service before being able to exercise it. They'll be able to take leave in a single block or in individual days here and there. And the leave can be used for care arrangements, help with financial matters, and accompanying people to appointments or to provide care. And it's intended that employees will self-certify their eligibility to take carers leave. And you won't be able to deny a request unless you believe that the business operation will be disproportionately affected. Any attempt to dismiss an employee, it's proposed as well, will be in connection with exercising their right to take carers leave will fall under the categories of automatically unfair. Next slide, please. Another new family-friendly right which is on the horizon is neonatal rights. Parents of babies who are admitted to hospital as neonate, meaning they are 28 days old or less, will be eligible for a maximum of 12 weeks neonatal leave and pay if the baby's admission to hospital lasts for a continuous period of 7 days or more. The government has confirmed that the employment bill, which is expected to become law soon, will legislate for this. However, a timescale has not yet been put in place. It's proposed that neonatal leave will be available to an employee from the first day of their employment, but those who have 26 weeks continuous service and earn more than the lower earnings limit will be entitled to statutory neonatal pay. This is in addition to maternity and paternity leave rather than instead of. And the government is proposing to prescribe a set period in which neonatal leave and pay must be taken. And it must be taken in a continuous block of 1 or more weeks. Parents who qualify will be afforded the same employment rights and protections as parents taking other family-friendly rights or leave. Therefore, they'll be protected from detriment or discrimination arising from them taking or seeking to take neonatal leave. The next slide, please. And another family-friendly rights on the horizon is that the government is also intending to improve redundancy protection for pregnant employees and maternity returners, with similar protections to be in place for people who are returning from adoption or shared parental leave. Government data shows that each year around 53,000 women leave their jobs when pregnant due to discrimination at work, and 1 in 20 are made redundant. Due to the pandemic and the increased financial difficulty and uncertainty that employers face, pregnant women and those on maternity leave have been at an even greater risk of being made redundant and discriminated against. And recent TUC analysis has found that since the start of the pandemic, 1 in 4 women and new mums have experienced new unfair treatment or discrimination at work, including being singled out for redundancy or furlough. It will be automatically unfair for an employer to dismiss a woman by reason of redundancy during pregnancy and maternity leave, and for 6 months after the end of their pregnancy or leave, except in specified circumstances. And those will be if the employer's business is closing down in the place where the woman worked, or the work she is employed to do is ceasing and she has not been offered suitable alternative employment. Similar protections will also be in place for women who experience a stillbirth or miscarriage. I will now hand over to my colleague Emma Bradding, who is going to discuss some recent cases on vexatious grievances and fire and rehire.
Thank you, Sarah. So as Sarah said, I'm going to discuss 2 recent cases and the Acas fire and rehire guidance. But firstly, I'm going to do a poll question. So that should come up on your screens in a moment. And that's, have you ever had to deal with an employee who has raised a vexatious grievance? So if you could all either answer yes or no to that. I'll just wait a few moments for the answers to come in. Okay, so 24% have had to deal with an employee who's raised a vexatious grievance. So that's not an insignificant number. And it may also be that individuals have had colleagues that have had to deal with that. So next slide, please. This brings us to the first case, which is Hope and British Medical Association. The judgment was published just before Christmas, and the case is significant because it indicates that the dismissal of an employee who raises frivolous and vexatious grievances can be fair. Now, I'll start by talking about the facts of the case. So Hope was employed by the BMA as a senior policy advisor from June 2014. He raised various grievances against senior managers. It wasn't possible to resolve the grievances at the informal stage, yet Hope refused to progress any of the grievances to the formal stage. But he also wished to keep open the option to progress them, and he did not withdraw the grievances. He did not turn up at the grievance hearing that was held with him in March 2019, even though he'd been told that his attendance was deemed to be a reasonable instruction. And none of his grievances were upheld at the hearing. Hope was then subsequently dismissed for gross misconduct. And the Employment Tribunal held, next slide please, that when Hope brought proceedings for unfair dismissal, that the dismissal was fair. Hope then appealed to the Employment Appeal Tribunal. Notably, he said that the Employment Tribunal should have considered whether the conduct relied upon to dismiss him was capable of amounting to gross misconduct in the contractual sense. The Employment Appeal Tribunal held that whether an employee is in breach of contractual obligations is a potentially relevant consideration to whether the dismissal was fair, but it's not fundamental to deciding whether a dismissal was fair. It's merely one of the circumstances to be taken into account under Section 98, subsection 4 of the Employment Rights Act 1996, when considering whether a dismissal was fair, and that Section 98, subsection 4 is where the statutory test is set out. It was said that here no contractual analysis was necessary, as the claim was not one of wrongful dismissal, and the BMA did not seek to rely on any contractually stipulated act as amounting to gross misconduct. Accordingly, the Employment Appeal Tribunal dismissed the appeal. So the case shows that even if gross misconduct has not been proved, the dismissal will not necessarily be unfair. Hope's conduct was a sufficient reason for dismissal. And it's useful for employers to be aware that, provided that a fair process is followed, an employee can potentially be fairly dismissed for raising frivolous and vexatious grievances. Next slide, please. So the next case that I'm going to discuss is Usdaw and Others and Tesco Stores Limited. This is a very recent judgment and relates to the firing and rehiring of employees. So between 2007 and 2009, Tesco reorganised its distribution centres, including relocating some centres. Tesco offered a contractual entitlement to retained pay instead of redundancy lump sum payment to staff as an incentive for them to relocate to other sites and remain with the company. This retained pay constituted an individual contractual entitlement. A collective agreement between Usdaw, the Union of Shop, Distributive and Allied Workers, and Tesco in 2010 stated that retained pay would be a permanent feature of an individual's contractual entitlement, although there were carve-outs relating to mutual consent, promotion, and adjustments to shift patterns. Tesco declared that it was planning to terminate the entitlement in January 2021. In return for agreeing to do away with the entitlement, employees were offered the equivalent of 18 months retained pay up front. Tesco said that if this was not accepted, it would terminate the employees' contracts and rehire them under new contracts, which would not contain such a right to retained pay. So it was proposing to engage in fire and rehire practices. Next slide, please. Usdaw sought an injunction on behalf of the 42 affected employees to prevent Tesco from terminating their contracts, and the High Court granted the relief sought. The High Court stated that it was necessary to imply into the contract of employment of each affected employee a term to the effect that Tesco's right to terminate the contract on notice could not be exercised for the purpose of removing or diminishing the right of the employee to retained pay. The court considered that the relief was just and convenient, as firing and rehiring the employees would operate to remove a significant proportion of the remuneration currently payable to the affected employees, causing, and it said, significant injury to their legal rights. The court also said that damages would not be an adequate remedy, given that the employees would be limited to the losses recoverable in any claim for unfair dismissal. Next slide, please. So following on from the firing and rehiring case of Usdaw and Tesco Stores, I'll now discuss the Acas guidance on fire and rehire. So firing and rehiring is a practice that's been in use for many years, although it arguably became more prevalent during the pandemic. There are concerns that the practice is used to weaken employees' terms and conditions, and that it's used as a tactic to prevent negotiations with employees about contractual changes. That said, some see it as reasonable when used as a genuine option of last resort, such as to prevent large-scale redundancy. In October 2020, officials at the Department for Business, Energy and Industrial Strategy, BEIS, asked Acas officials to carry out an independent fact-finding exercise with stakeholders to inform BEIS's thinking on this issue. Acas published a paper on the use of fire and rehire practices at work in June 2021. It should be noted that the government blocked a private member's bill that attempted to stop fire and rehire in October 2021. That said, in response to the paper that Acas had published, BEIS asked Acas to produce guidance to help employers explore other options first before considering hire and refire to change employee contracts. And Acas published its guidance, which is termed advice, quite simply, in November 2021. P&O Ferries is in the news at the moment, and I'm sure lots of you have read about it, and that's due to them dismissing 800 members of staff. While this is not a fire and rehire scenario as such, because P&O is not rehiring the employees dismissed, it has raised questions on the use of fire and rehire. And earlier in the week, MPs voted in favour of an opposition day motion demanding that the government take action to improve employment protections, although the government itself abstained in the vote. So it will be interesting to see if the government does indeed legislate on fire and rehire as a result. So it's very much a space to be watched. Next slide, please. So employers should still consider following the Acas guidance, even though the government hasn't at this point legislated on fire and rehire. Employers will often try to negotiate with employees to change terms and conditions of employment before firing and rehiring employees. And the Acas guidance from November is useful in flagging risks that employers should consider associated with changing T's and C's. You can see some of the considerations listed there on the slide. So we've got damage to working relations, and of course, linked with that, a decrease in commitment and performance if employees don't support the changes or feel they've not had the opportunity to inform decisions that are made by the employer. We've also got legal claims. So for example, claims of breach of contract or constructive dismissal could be brought by employees. Reputational damage, damage to the organisational brand, making it difficult to attract new employees, as the guidance points out. And then industrial or collective action. So collective action being where there's a action taken by a group of employees that's not authorised by a trade union. And the guidance stresses that employers should only consider dismissing and offering to rehire someone on new terms as a last resort. Before dismissal, employers must have made all reasonable attempts to breach agreement through a full and thorough consultation. It's worth remembering that if employers are proposing to dismiss and rehire 20 or more employees, they're legally required to collectively consult on the proposed dismissals. And ultimately, employers should fully consider their options prior to engaging in hiring and refiring practices, and they should ensure that they fully understand the risks. I'm now going to hand over to Devan.
Thank you, Emma. And as Emma said, it's really come to prominence, fire and rehire, at the beginning of the pandemic, where employers were having to consider this on a mass scale across the board because of desperate changes that were required in a very desperate situation. I think there was probably a little bit more leeway or at the time in terms of employers, the way they were going about it. So we're now going to move on to immigration, and Elliott's going to talk to us about the challenges we've had, sort of, I think, 12 months or so of the new points-based system post-Brexit. We call it a new points-based system. It's just an adaptation of the old one, but it's thrown up quite a few challenges. So I'm going to hand over to Elliott now to talk about that.
Good morning, all. I spoke at last year's webinar about the most significant changes to the UK immigration system in over a decade, which were described at the time as a seismic shift in UK visa policy. And more than a year on from Brexit, we're seeing the ramifications of that policy shift and can guide employers on how best to navigate the new immigration system. And that really forms the basis for today's talk. Can I have the first slide, please? So as you very likely know, those who have valid immigration status under the EU settlement scheme can continue to live and work in the UK, and they can also bring certain family members to the UK as well. From a broader immigration standpoint, what Brexit really means is the end of free movement for EEA nationals, and those individuals now require sponsorship under the UK points-based system if they don't hold EU settlement scheme status or another type of visa that allows them to work in the UK. Next slide, please. So for the first time, European nationals require the appropriate visa permission to work in the UK, and that appropriate visa permission would typically mean an employment visa. So to facilitate this, the points-based system has undergone a large-scale redesign, and with it, the Tier 2 general route for new hires has been overhauled into the skilled worker route, while the intra-company transfer route for existing group company employees who are coming to the UK has remained broadly the same, but will shortly be undergoing a major revamp that I'll go on to describe shortly. The government's also introduced some new right-to-work checks as an offshoot of that, the rollout of which has been complicated by the pandemic. And businesses have really had to navigate these changes simultaneously to assure the continuity of their existing workforce and to ensure that they have the ability to recruit non-UK nationals. That in turn has incurred new administrative burdens, costs and recruitment timescales that previously didn't exist when the transfer of European nationals could be done very swiftly and without calls to really consider, long lead-in times for recruitment. Next slide, please. So the common question that businesses typically ask us is how they can maintain their ability to hire non-British nationals. And the answer to that fundamentally is through sponsorship, which is really the key to fluid recruitment. Now, obtaining a sponsorship license, if you don't already have one, is a time-consuming, costly and admin-heavy process, but to my mind, the benefits really far outweigh the pain of applying. Once you have the license, you have it for 4 years and you can use it to sponsor any number of workers. And that sponsorship itself can come in 2 forms, which really cater for different kinds of applicants and work arrangements. And they are the skilled worker and intra-company transfer routes that I mentioned a short while ago. So the skilled worker route first, that is a simplified route for new hires, and it introduces lower skill level and salary thresholds than what came before, which allows, excuse me, for the recruitment of a wider range of more junior positions. Thankfully, the advertising requirements that haunted Tier 2 sponsors have been abolished entirely, which speeds up the whole process considerably. The English language criteria has also been broadened, which allows applicants to draw on a far wider range of qualifications to prove their English skills. And the route still leads to settlement, and workers can typically apply for indefinite leave to remain after 5 years of continuous residence. Next slide, please. So the intra-company transfer route, as is, will shortly undergo a major overhaul, and within the next month, we'll see the introduction of a new type of visa called the Global Business Mobility System. So that's going to replace the intra-company transfer route with 2 new types of visa, one for senior and specialist workers, the other for graduate trainees, while there'll be additional routes for secondees, service suppliers and representatives of overseas businesses who are setting up in the UK, and they will offer further options that aren't currently available. Like the ICT route, these don't have any English language requirements and they won't lead to UK settlement. So they won't always be applicable in the circumstances depending on the nature of the type of assignment that you want your employee to be undertaking. Those new routes were only announced a matter of days ago, and the detail and sort of practical application of each is yet to be seen. But I would anticipate that in some cases, at least, it should offer more flexibility for businesses who are looking to transfer their staff to the UK. Aside from those 2 routes and looking outside of a sponsorship sphere, there are a few alternative visa options, but they are limited in scope and they aren't always going to apply. And it's very much dependent on the circumstances of the individual you're recruiting. The Ancestry Visa can be used by Commonwealth nationals with a British grandparent. There's a Tier 5 route that allows interns to be sponsored for short-term work experience assignments. You can employ students within certain limitations during the course of their studies. And there are also family visas that offer other alternatives depending on the nature of the family relationship and the type of visa available. And they really apply to both British and non-British nationals, but as I say, they are limited in scope and application. It's worth keeping those in mind, as they might just offer a cost-effective and potentially more straightforward alternative to looking at the sponsorship regime. But I would say, in my experience, the skilled worker route typically wins the day in the long term, as it gives you the most flexibility to move quickly on any new hires, and it also has a good long-term application in the sense that it leads to settlement in the UK as well. Next slide, please. So turning to practical tips for recruitment for UK businesses, my main recommendation would be really to plan ahead and to appreciate the timescales involved in each stage of sponsorship. So if you don't, excuse me, if you don't already have a sponsorship license, obtaining that can take 6 to 8 weeks, albeit there is a costly priority service that is unfortunately quite difficult to get onto in the first place. For the applicants themselves, English language and tuberculosis testing might be required depending on their nationality and their country of residence, and those can both take several weeks to obtain and involve discrete costs themselves. The visa application could take 4 to 6 weeks depending on where the application is being made and the availability of biometric appointments. Albeit I would say that one benefit we've seen in more recent months is the widening of UK visas and immigration's digital services. So those who have biometric residence permits in the UK and already have that visa in place can now avoid the need for a visa appointment when applying for within the UK in certain circumstances, and they can use a bespoke ID verification app to effectively enroll their biometrics online. So they avoid the need for the appointment. That does speed up the visa process, and it's been quietly introduced with little fanfare as we see the shift on UKVI's end towards a fully digitized immigration service. And I think over the next couple of years, we'll see overseas applications moving in that direction as well, which in theory should further speed up the process, probably by a couple of weeks or at least several days. It's also important to consider the potential pitfalls of any application, and you should take into consideration for anyone you're recruiting their immigration history, whether their nationality requires them to prove their English language skill, and then factor that into the prep time. Consider whether tuberculosis testing might be required based on their residence and the country where that is mandatory. Look at their salary and ensure that you prorate it to avoid falling short of the visa application salary thresholds. And from a slightly different perspective, but thinking back to those family member options, we've also seen increased scrutiny of unmarried partner dependent applications, and UKVI's apparent policy decision to apply a strict requirement for applicants to submit evidence of 2 years of cohabitation, which could be prejudicial for an unmarried partner application, which might then impact on the desire of an individual to relocate to the UK if they wanted to bring their unmarried partner with them. Elsewhere, as a sponsor, you should invest in record keeping and reporting systems to keep on top of compliance obligations if you haven't already done so. And there are some HR software programs available for that purpose that can really give you, I guess, a one-stop shop for record keeping and reporting. Next slide, please. On which note, UKVI's right to work guidance has changed periodically over the last couple of years. And certainly, I think in the last 6 months, it feels like there's been a rolling sort of raft of changes that we've been trying to keep on top of. So I'm going to briefly recap the current position and highlight some of those more recent changes just to give you a steer on sort of what that side of the immigration sphere looks like and what's coming slightly further down the line. So right to work checks should be undertaken for any new employees, regardless of nationality, and that gives you as the employer a statutory excuse against a civil penalty if that employee is found to be working illegally. Up to 30th of September 2022, you can continue to check original documents via a video call against a digital copy of the individual's documents. And then from the 1st of October 2022, you would need to undertake either a manual in-person check, as you had done pre-pandemic, or continue to do an online right to work check. There's a further change coming on the 6th of April 2022, where the Home Office are going to make available what's called an identity document validation technology, which you can make use of via what they've called an identity service provider. So a few different terms to sort of get your head around there. And those IDSPs will be able to complete the digital identity verification element of your right to work checks, initially just for British and Irish citizens, to sort of take some of that burden away from you as the employer. Where you have new employees who are relying on a document, excuse me, or a visa that gives a time-limited excuse. So for example, if they had a family visa or even a skilled worker visa, it's necessary to carry out a follow-up right to work check when that visa expires to make sure that they retain the right to work in the UK. It might, in some cases, also be necessary to undertake what's called a positive verification notice check from the UK Visas and Immigration Employer Checking Service, and that will sufficiently demonstrate an individual's right to work for a period of 6 months, and it gives you a statutory excuse against a civil penalty for that 6-month period. You need to keep copies of all right to work documentation on the individual's personnel file, and in addition to that, there are also some fairly stringent and wide-reaching record-keeping duties as well. They're too numerous really to list here, but sponsors should certainly seek to clarify those requirements if they're uncertain, and that includes pay slips, contracts, job specifications, and other information. So that brings me to the end of what's a fairly whistle-stop tour overview of the UK immigration changes. Thank you for listening, and I hope it's been useful. Now I'll hand back to Devan.
Thank you, Elliott. And I think, you know, as Elliott said, there are lots of little changes happening all the time. I mean, the right to work checks has been probably changes every couple of weeks the last couple of months, and you know, so I think the key is, you know, just because a system sort of in your application or a way of applying happened once, it doesn't mean the next time you make your application it's going to be the same, because things are changing quite rapidly, little changes here or there. So it's worth bearing that in mind. But we're certainly seeing a lot more activity in the immigration field post-Brexit. I'm now going to pass over to Aarti, who's going to talk about the government's plan for living with COVID, with a particular focus on the requirement to isolate and sick pay implications related to that. Over to you, Aarti.
Thanks, Devan. Morning, everyone. Can I have my first slide, please? Thank you. So on 21st of January this year, the government launched its Living with COVID strategy. And the intention here is for us all to move on with our lives and learn how to live with COVID. So currently there is no requirement to isolate, but the guidance until 1st of April is that you do if you're COVID positive. However, from 1st of April, there'll be no requirement to isolate and not even any guidance to recommend that people do. So from 1st of April, individuals have to make their own decision as to whether they isolate or not if they're COVID positive. The difficulty obviously is for employers here, because there's no legal basis to require employees to isolate. So it's up to each employer to set their own policies and rules on this. And the main question, therefore, what can an employer do if their employee is COVID positive? So this might be a good point for a poll question, which you will see on your screen momentarily. So are you requiring staff to self-isolate if they test positive for COVID? And that's the moment. Oh, that's interesting. So at the moment, 82% of you are requiring people to self-isolate and 18% are not. So how do employers treat COVID positive employees? If an employee is unwell with COVID, then obviously the usual sick pay rules will apply. If an employee is not unwell, so they're asymptomatic and they're able to work from home, then the sensible option would be to allow them to do so and pay them accordingly. The difficulty arises where an employee is asymptomatic, so they're not unwell, but they're not able to work from home. And an obvious example would be those who work on a shop floor or on a building site where they're not able to do their job from home. So can an employer require such employees to self-isolate if they're asymptomatic? The key question is, what do you pay someone who you're asking to self-isolate when there is no legal requirement to do so and when they are well enough to perform their work? So from today, actually, statutory sick pay is not available for an employee who feels perfectly well. So an asymptomatic employee would not be eligible for statutory sick pay. Obviously, if they're sick, then the normal sick pay rules will apply. Similarly, employees who are asymptomatic may not fall within a company sick pay policy, because usually the sick pay policy requires someone to be absent through illness, which wouldn't be the case if they're asymptomatic. Obviously, unless the policy has been amended to specifically reflect that, but I'm assuming that that's not the case for most employers at the moment. The difficulty with treating an asymptomatic employee as though they're off sick for the purposes of sick pay policy is that this could skew the number of days that someone is absent through sickness for the purposes of attendance management. So someone who wouldn't ordinarily trigger any attendance management review might well do so if they, have COVID and are asymptomatic. So they're not actually sick, but it might result in them having to be, go through an absence management process, which kind of defeats the whole purpose of such a process. So essentially, asymptomatic COVID positive employees who work from home or who cannot work from home would need to be paid full pay during such a period where they're required to stay away from work. The risk of not doing this is an unlawful deduction of wages claim or a breach of contract claim. The exception here is, firstly, if the contract allows it. So the contract says that an asymptomatic employee can be paid anything less than full pay, although, again, I assume this isn't the case for most employee contracts. Or secondly, if the employee and employer agree that the employee will be paid less than full pay for such a period. Otherwise, in any other situation, if you don't give them work when they are well enough to do so, and you don't pay them, then this could be an unlawful deduction of wages claim. There are a couple of risks of both approaches, just briefly. So the risk of not paying full pay is that you might find that employees who are asymptomatic or those who are aware they've been in contact with COVID either don't disclose to the employer that they are asymptomatic, or indeed don't test at all because they're worried about what the effect of having COVID will be on their pay and their work. So you might find that people are coming into work without disclosing their COVID, that they're COVID positive, and this could result in a spread of COVID across the workplace, which is obviously not ideal. And on the other side, the risk of paying full pay is that you might have the odd employee who falsifies a COVID positive result. If they're able to sit at home and not get full pay, then some people might say that they're asymptomatic when they're not. So the advice would probably be to make sure your disciplinary policies are amended so that falsifying COVID records could be a disciplinary offence. Another poll question, just out of interest, which will come up on the screen shortly. What are you paying staff if they are COVID positive but can't work from home? And the options are SSP, contractual sick pay, full pay, which is not a sick leave, nil pay, or depends on vaccination status. Interesting. So everyone is paying some sort of something if people are off work due to COVID but not able to work from home, and no one is differentiating between vaccinated and unvaccinated, which is interesting. So thank you for voting on that. So whilst most employers will want to limit COVID exposure in the workplace, there may be some employers who want employees to attend work if they're asymptomatic. An obvious example might be those who work on a building site. So an employer obviously needs these employees physically to be able to work to do the construction, without which there'll be delays and it's not possible to carry on the work. And also employers might think, oh well, people are working outdoors, the risk is less, and therefore we're willing to have people who are well enough to come to work and want them to do so. So can an employer force someone who is asymptomatic to come into the workplace? Legally, because there is no requirement to isolate, employers can require employees to come to work. We'd recommend if you did this, then you'd have a clear policy setting this out so it's clear what's expected of employees. But notwithstanding this, employers should be mindful of the duty of care, not just to the asymptomatic employee, but also to other employees, especially those who might be classed as vulnerable. Additionally, it's important to think about the employee's views more generally. Employees may think that the employer doesn't care about their health and safety if they're knowingly being exposed to the risk of COVID. This might create, a dissatisfied workforce. It may make people less motivated, and just generally might not be a great environment at work if employees feel their employer doesn't care about them. And an interesting point on this is that Wilco recently apologised for what they called was some miscommunication when they sent out a memo to all their staff saying that if the employees are asymptomatic, they can still come to work. And this caused huge uproar with the employees who said it's absolutely ridiculous, and they were very unhappy about this. And Wilco then did a U-turn and said, no, sorry, miscommunication, please don't come to work if you're asymptomatic. So this is just an example of how, you know, the rules allow employers to require people to come to work, but if you think about how the employees are going to react, your decision may be something different. And in a similar way, clients and customers, it's not just employees that companies need to think about, it's about clients and customers. If you have clients who come in for regular meetings or come into the workplace, you know, how would they feel if they know that, you know, your policy is that asymptomatic employees can come to work in the usual way? It might mean that people stop wanting to do business with you. It might mean that people stop wanting to interact with you in the office. So that's something to think about as well. It's a reputational issue as well as a safety issue. And another interesting point, prospective employees, the way that, you know, when you have people coming in for interviews, they ask about what's your holiday policy, what's your benefits policy. You might find that prospective employees now ask what's your COVID policy, and if they're told our policy is, you know, you must come to work if you're asymptomatic, again, it could result in losing good talent of people that don't want to take that risk by coming to work when COVID is around. So they're just a few things to think about outside of, you know, what's legally allowed and what's not. Next slide, please. So this is a recent case in the Employment Tribunal case, which is not on exactly the same point about whether a COVID positive person can be forced to come to work, but is a similar issue. So in this case, Mr. Quelch refused to return to work at Courtier Support Services. Well, he refused to return to work physically during the government's work from home if you can advice on the basis that his girlfriend was classed as medically vulnerable. And he was told that if he didn't want to return to the workplace, he could either take unpaid leave, annual leave or sick leave, or be disciplined if he refused to return. And bear in mind, there was no reason why he couldn't work from home, and there were no performance concerns of him doing so. However, his employer believed that what he did, he was a key worker, and therefore he shouldn't work from home, even though the government's guidance was to do so. And because he refused to come to work, he was dismissed for gross misconduct. And the tribunal held that he was automatically unfairly dismissed under section 101D and E of the Employment Rights Act, which is in relation to health and safety dismissal. And the tribunal also found that it was unfair under ordinary unfair dismissal. And their reasoning was that Mr. Quelch genuinely and reasonably believed that there were circumstances of serious and imminent danger to him and his girlfriend. And this is on the basis that he was due to share an office with two other people, both of whom had children at school, and therefore, you know, at that time COVID was spreading like wildfire within schools, and so he believed it was a genuine risk to him and his girlfriend's health. Now, this case was heard during a time when self-isolation was mandatory, although work from home if you can was in place. So it's arguable that a tribunal may be more sympathetic to serious and imminent danger now for employees who are vulnerable on the basis that, you know, that there are likely to be people in the workplace who are asymptomatic, and the risk of catching COVID is therefore higher. But on the other hand, the fact that the population as a whole is now better protected against COVID, excuse me, the dominant variant is less severe, and the legal obligation to self-isolate has been removed, the tribunal might, on the other hand, be less sympathetic to employees who try and argue serious and imminent danger on the basis that the risks of actually seriously being injured with COVID are a lot less. So it's yet to be seen how a tribunal will deal with those kind of issues. But it will, of course, depend on individual circumstances, and, you know, if someone can demonstrate a particular vulnerability or, you know, serious harm from COVID, of course, the tribunal will be a lot more sympathetic in those situations. So essentially, requiring an employee to attend the workplace is now more likely to be a reasonable management instruction than it was earlier in the pandemic, but disciplinary action could still result in constructive unfair dismissal claims. So it's really important that employers explore the basis of the employee's concerns both before and during the disciplinary process, if appropriate, in order to make sure there are no extenuating circumstances or vulnerabilities they should consider in order to minimise the risks of such a claim, or at least successful claim. Next slide, please. And finally, what steps should employers be considering in light of the government's proposed measures? Now, whilst the end of the legal obligation to self-isolate doesn't prevent employers from having their own more restrictive rules on workplace attendance, if they choose to do so, employers should have policies in place setting out their rules in this regard. Excuse me. As testing will no longer be free and therefore employees are less likely to test, employers might consider the following steps. So purchasing some home testing kits for employees if they are displaying symptoms or they're concerned about COVID, continuing to encourage employees to be vaccinated, or keeping in place rules on face coverings, hand washings, and other safety measures which don't do any harm but might further reassure employees that the workplace is safe. So in summary, the government scrapping all rules doesn't mean that COVID is gone for good, but it's sensible for employers to be cautious, keep employees' views in mind, sorry, and having a clear policy, keeping an eye on what the market is doing, and being adaptable to further change.
Thank you, Aarti. And I think it's important to note that employers still have this duty of health and safety in the workplace, and I understand from 1st of April there's no obligation to refer to COVID as part of that, but I still think it would be sensible to include it and document your decision making. So if you decide that you are requiring people to come to work, or whatever you are deciding in respect of COVID, if it's documented, then at least you can show you've thought about it, you've considered the risks, etc., etc. So I think it's really important to do that. So we're now going to enter the Q&A section. We have already had a few questions, but a reminder to put your questions in the Q&A tab at the bottom. Please do put your name, because we don't have too much time left. So if we don't get to your answers, then at least if we have your name, we can contact you separately. The first question we've had is for Sarah Gill. When are the new family-friendly rights around careers, leave and redundancies for those on mat leave, following mat leave, due to come into effect? Sarah, are you able to answer that?
Yes, yeah, I can answer that. I'm struggling to put my video on at the moment, so you might just have to have my voice. But yes, they're due to come into, we don't yet know there's the answer, is because the legislation that underpins this is still going through Parliament, and it's still in the preliminary phases, really. It's essentially what we're looking at is the employment bill. The last time I looked, that was still going through Parliament, and it was supposed to have a second reading, which is a relatively early stage in the process, in May this year. And so it's got to go through second reading and various other stages, and third reading, and then go to the House of Lords. So I suspect that the family-friendly rights that we referred to earlier probably won't come into effect until later this year. It won't be in a hurry, as it were. And because a lot of the changes I mentioned are not yet law, and they're just kind of the government's wish list, or kind of linked to legislation that hasn't yet made it through the parliamentary processes, a lot of the detail is not yet known to us, so it's difficult to kind of answer the minutiae of questions, and so that's unfortunately we're kind of at that stage at the moment. However, as and when we do have more detail, because I know that you're interested in that, we will produce alerts and updates and share those with you, so that you've got as kind of as much notice of them as possible.
Thank you, Sarah. And there's a further question, which is also for Sarah. So, anecdotally speaking, have you seen an increase in the number of employment tribunal claims lodged? And if so, what type of cases are being raised?
Yeah, so we have. The short answer is yes, there has been a significant uptick in employment tribunal claims. I think the last figures we had ran until March last year, and they were saying that that was the biggest number of tribunal claims we had seen since 2013. Most of the claims that were coming into the tribunal system were related to furlough and redundancy. Now, we don't have the figures for this year, but I expect similar news this year, because obviously the furlough scheme would have been wrapped up, and people who perhaps should have been made redundant during that weren't until the end of that scheme. So I imagine that we're not going to see a significant decline in claims. We've also seen some murmurs and starts of claims arising from mandatory vaccination. And I know there's been kind of a bit of a hokey cokey on that. It's introduced, and then it tends to be a bit more relaxed about it. But there were some claims in the tribunal system about that as well. But I think the pandemic generally has made the tribunal system much more sluggish. It's taken them so much more time to deal with things. I mean, you can't get through to them on the telephone for love or money. And it's made everything more difficult in an already under-resourced system. And of course, they were already dealing with a lot of kind of major equal pay class action cases against the supermarkets, for example, which were kind of overwhelming the system. I mean, I've had experience of tribunal claims where you kind of put them in January, and then there is, you know, the other side aren't even notified of them for kind of 5 or 6 months. It depends where you are in the country, but things like that are happening at the moment, unfortunately. Great news for employers, though, because you don't have to deal with them so quickly, and it may make people more amenable to settling once they do come into the tribunal system, once you get wind of them, because they've had to wait even longer than usual.
Sarah. So the next question we have is for Aarti, and it's, can vaccinated and unvaccinated employees be treated differently for the purposes of sick pay?
Hi, sorry about my coughing fit earlier, everyone. I'm back now. So that's an interesting question. It's one we got asked quite a lot at the beginning of the year, when the government said that, you know, there are differences in the way that vaccinated and unvaccinated people have to isolate. So I think the beginning of the year, if you came into close contact with someone with COVID, if you were vaccinated, you didn't need to isolate, whereas if you were unvaccinated, you'd have to isolate for 10 days, I think it was. And so we got a lot of questions at the time, and the answer is, well, yes, technically you could treat people differently for the purposes of sick pay on the basis that the government allowed you to. However, there was quite a lot of this in the press, where some household names were very vocal about differentiating and others weren't. So IKEA was one that said that for unvaccinated staff who had to isolate due to close contact, they would pay them SSP only, whereas if you're vaccinated and you were required to isolate, then you get full pay. Although IKEA were clear that if you were positive, you were COVID positive, you would get full pay even if you were unvaccinated. The difference was only if you were required to self-isolate due to close contact. Whereas John Lewis, on the other hand, they were, I think, one of the household names that were very vocal about not differentiating, and they said it's not fair, not ethical, and they were going to treat everyone the same. So I think essentially from April, when the rules are scrapped and there's no difference between the way, there's no rules for anyone, vaccinated or not, it'll be very difficult to not treat everyone equally and to make any kind of differentiations, because without the contractual right, without the government's rules, it could result in both discrimination and unlawful deduction of wages claims. So it's very risky to make those kind of differentiations. And even more importantly, with the lifting of the regulations that required healthcare workers, frontline workers and care home workers to be fully vaccinated, there's even less justification for differentiating based on vaccination status. So I think now, going forward, treating people differently in terms of pay or otherwise based on vaccination status could result in a number of claims, including but not limited to discrimination. Back to you,
Thank you, Aarti. We're at the end of our session. We can go on a few more minutes, but I know that some of you may need to drop off. So the next question is for Elliott. Do you have any advice on the humanitarian visa sponsorship options for employers of Ukrainian nationals living in Ukraine? Because this is obviously something that we're seeing questions on, and obviously a very difficult situation there at the moment. Elliott.
Thanks, Devan. So there are a few different options, both on the sort of humanitarian side and also on the more standard visa side. So I'll start by looking at the humanitarian ones. There is a Ukrainian sort of sponsorship scheme which allows individuals in the UK to offer accommodation to Ukrainian nationals for up to 6 months. And it has to be a pledge for a minimum of 6 months in order to be accepted onto that route. If they do that, the government can offset the cost of living by providing a £350 per month allowance. And I understand the government will also undertake checks on the individual who's offering the accommodation. That is being extended to companies as well. So a company could provide, say, a company-owned flat for a family or for an individual from Ukraine to come over and stay in. Again, I believe that's a 6-month minimum offer that needs to be made. Aside from those couple of humanitarian options, Ukrainians can apply for UK visas through any country really in Europe. So if they're able to get to Poland, for example, or Romania or elsewhere, they can apply for for a UK visa, and that could be a sponsorship visa or a family visa or anything like that. And what UKVI has done is they've stripped the requirement for Ukrainian nationals to go to appointments at the visa application centre, so they can now actually give their biometrics, rather than at the visa application centre, they can give their biometrics within 6 months of arriving in the UK. I think initially it was quite shambolic in how those kinds of visa applications are being processed, but obviously we're now a month into the conflict, and I think UKVI is making a real concerted effort to make the visa applications and this sponsorship scheme as accessible as possible and as smooth as possible. There's obviously more detail to it than that, but as a kind of a high level overview, they're really I guess the three sort of main options. But I'll be very happy to have another chat with whoever raised the question if there's more detail that they would like to hear.
Thanks, Elliott. Our next question is going to be for Emma Bradding. Can you include a clause in the employment contract allowing the employer to change the terms of the contract to get around the issue of having to get employees to agree to the change?
Thanks, Devan. So yes, it's kind of generally understood the basic position is that contracts can't be unilaterally varied. So some employers do seek to include specific flexibility clauses in employment contracts, such as in respect to working hours and working location. But courts and tribunals will interpret such clauses very narrowly, and if there's any ambiguity, then the interpretation will be in favour of the employee. So the key is to be explicit in the contractual wording, and if there's an implied term in the contract, this might trump the flexibility clause. Although case law has actually shown that in some instances courts will imply terms into the employment contract that will be beneficial to employers. So, for example, to permit a change in working conditions in some instances. So if there was an employee, they may be expected to change their place of work as long as it's within a reasonable travelling distance of their home. I think where clauses are more general, so they just purport to give the employer the right to make any change it likes, then it's very unlikely that a court or tribunal would uphold that.
Thank you, Emma. I think that's going to take us to the end of our questions for today. If there's anything we didn't get to in the Q&A, if you've got your name there, we will get in touch and let you know. But I want to say a big thank you to everyone for attending the webinar today. It was, hopefully you found it useful. Please do let us know in the feedback what you found useful. What would you like to hear about our next webinar? And thank you very much, everyone. Thank you.